Hi, good morning. This is Jonathan Pompan, and so for those on the West Coast, thank you for joining us, and good afternoon for those on the East Coast. Again, this is Jonathan Pompan at Venable in Washington, D.C., and welcome to CFPB Complaints, Compliance, and Enforcement Trends and Tips on Wednesday, February 17, 2016, co-sponsored by Venable and Performline. David, how you doing today?
Doing great. Thanks for joining us today, everyone. And Jonathan, always a pleasure to be on with you.
Great. Thanks, David. And for folks that don't know, we've got some regular attendees, I know, to Venable webinars. But for folks that are joining us from the Performline side, Venable is a national law firm with a CFPB compliance practice as well as advertising and marketing and, of course, other practice areas in the business transactions and litigation setting. Our CFPB task force is comprised of a number of attorneys that practice before the CFPB on related regulatory issues. Thank you for joining today. David?
Great. And Performline was founded back in 2008. We're a web-based technology company that is solely focused on marketing compliance. We have a team of industry experts and technology experts, and we have a platform called Perform Match that gives real-time automated monitoring of marketing content, both on the web as well as in call centers. We discover, monitor, and score billions of potential violations for our clients every day, and we're very focused around a number of different aspects that our clients hold in critical regard to their marketing compliance practice. I think one of the reasons why we're probably all on the phone today is the core market challenge. That's truly the complying with regulations over multiple channels, as well as multiple agencies, whether they be state, local, or federal. At the very least, can be complicated, labor-intensive. It can seem expensive to try and attack it ahead of time, and it's egregiously expensive when you find yourself on the wrong side of it after the fact. So when clients engage with us, they're very much focused on three critical areas that we help them with. That's based around what we call the DMAs of marketing compliance, and that's to discover, monitor, and act. So to use technology to discover potential violations automatically. So whether that be a known advertisement or a known contact center issue that you're having, or if it's something that's wholly unknown to you, where someone is using non-compliant ad copy or language or an unapproved use of your service marks, trademarks, or logos. We monitor your risk signal with our always-on technology within our platform. So for people in the digital advertising world, we screenshot and monitor every single ad placement you have every 24 hours and score it so that you have an unquestionable audit track of oversight in that perspective. And then whether it's contact center monitoring or web monitoring, our workflow tools and remediation tools are really built so that when you act, you have an automated closed-loop reporting format within the platform so that you no longer have to question the accuracy and how up-to-date reporting is on all open items and all risk signal across your enterprise.
Thanks, David. So now for some kickoff administrative items. Again, for those who have just joined us, welcome to CFPB Complaints, Compliance, and Enforcement Trends and Tips. You're joined today by David Morgan, the Chief Revenue Officer at Performline, and I'm Jonathan Pompan, a partner and co-chair of the CFPB Task Force at Venable, located in our office in Washington, D.C. this afternoon. And thank you for joining us. Today's session is going to focus on CFPB complaints and compliance enforcement's trends and tips from the front lines, both from the compliance front lines as well as also the battlefields of CFPB engagements, including enforcement matters, supervision, exams, and of course just day-to-day regulatory issues that are handled by myself and others on our CFPB and regulatory teams. But importantly, today's session is not legal advice. David is not a lawyer, and while I am one, we're not providing legal advice today to anyone on this webinar. But importantly, though, if you have any fact-specific questions, please save those for your legal counsel of your choice. But we will take questions throughout the session today using the chat feature in ReadyTalk. And so please feel free to send your questions in. Both David and I can view that, and we will bring them up as we go. Also, today's presentation is going to be available later this week on venable.com/CFPB/publications, and also on the PerformLine website and blog. And we'll have it in downloadable form, both the slides as well as also viewable in video form as well with the audio track. For those of you who are attorneys and are on in part because there's going to be CLE today, there'll be a certificate provided via email to participants after today's session. I'm sure all of you know the drill, but there will also be a code, and that code will be provided at the very end of today's webinar. So today when we are talking about stuff, David, we've often chatted offline about the sort of the not novel, but certainly the amped up attention that consumer complaints are receiving. And I know that PerformLine and you have done an amazing job of really drilling down on what is the publicly available information from the CFPB in terms of the complaint database. And then also, you certainly have that context from the work that you do too, working with your customers who not only need to be able to address complaints, but anticipate how to address them even before they happen.
Yeah, and thanks, Jonathan. That's correct. So as part of what we've been analyzing in the marketplace, we've been looking a lot at what's available from regulators such as the CFPB, and the CFPB actually has a great level of transparency and forward-looking guidance that they provide. And one of the innovative things that they've been doing is publishing the consumer complaint database. And so what we've done is an analysis on the consumer complaint database, and this is actually some updated information with the second iteration of this, and we're working on a third iteration of this research too. But just a little kind of level set on the CFPB complaint database. CFPB was created as a function of the Dodd-Frank Act, but the CFPB complaint database first began receiving consumer complaints back in July of 2011. In June of 2012, they began publishing that select information from the consumer complaint database online, and it's visible if you go to cfpb.gov. This is not something we have special access to. This is something that anyone can access.
And it's highly manipulatable. For folks that haven't been on there, you can download it into Excel or other software, do pivot tables, all sorts of analyses, really robust information. What's interesting about this, of course, because it is controversial, David, a lot of companies would prefer that not to be publicly available. Would have preferred that the CFPB go more like the FTC route, where the FTC collects complaints but doesn't publish them except in very aggregate form.
Yeah, so this is very detailed. This is actually at the instance level in terms of granularity. So when we started looking at this, we in January again refreshed our data, and there are over 505,000 complaints, and they've been sent out. When complaints come in, they're sent out to the companies for response, and there are about 3,000 companies that are the aggregate recipients of these 505,000 complaints. Complaints are published after the company responds to them or after 15 days from submission, whichever comes first. So we started looking at this data to say, are there correlations in here by industry or other connective tissue so that companies we work with and other companies in the space can look at this and try and deduce where there are potential risk signals they need to be aware of. So if you click forward there, Jonathan. So this is our second iteration of our analysis. So there are two graphs here on the page, and what you see on the left is the growth in the consumer complaints, right? So again, this consumer complaint database was not published on the site until 2012, started collecting them in 2011, but you can see there's been an exponential growth since the public has become knowledgeable that this exists, and there's definitely a huge amount of growth year over year, and on average it's been about 33% growth since 2012. The graph on the right goes one step further and looks at this by industry. So if you look on here, there's two things I would point your eyes to. Right? So the first is the yellow line. So the yellow line is the mortgage industry. So from the inception of the complaint database forward, the mortgage industry has been one that has dramatically garnered interest as it pertains to consumer complaints. But the second one there is debt collection. So there are two ways to look at this graph. One is, where are there trend lines that are high? And the second is, where are there trend lines that are on the rise? So debt collection, which can span any one of a number of industries, is the second most complained about type of consumer entry in the complaint database. After that, we go to credit reporting, and then credit card, bank account services, consumer loans, student loan, payday loan, so on and so forth. So when you're looking at this, some of these things may be core to the type of business you run or a line of business within your company. Some of these may be other sections within your company that are servicing your consumers. Some of these may be activities performed for you by third-party companies, right?
And David,
I'm calling debt collection.
What's interesting there too, and that's a very good point about how they could be essentially subsets of a company. So you could be a mortgage company. So this is trend data by industry. But for instance, a mortgage has payments. It's got advertising and marketing in it, debt collection. It runs the gambit of activities within an industry. And so each one of these industries also has a cross-section of different types of complaints too. Oftentimes, it can be very similar across industries, and the CFPB has drawn a tremendous amount of attention to that in what they call supervisory highlights, as well as also in some of the information they've put out just about the complaints. But CFPB, of course, examines many larger participant industries within the non-bank space as well as banks, and as a result of that has put out these highlights where they're taking what they see in the field and then they're also commenting on that, matching it up to the consumer complaint database, much like a company might do internally if they were doing a compliance audit or review to assess gap analysis.
Correct. And one of the things to note on this graph too is, as the scale of the mortgage complaints and the debt collection complaints are so high, you may not accurately see on this graph how sharp the uptick in some of the lower levels are. So if you participate in some of the other areas listed here, I would recommend that you look at the data that's available and you filter it by your industry specifically, because there are some industries here that are seeing dramatic near-term rise. One thing to note about this graph, the order in which those industries are called out there is by order of magnitude in terms of complaints.
Yeah, and David, it wasn't until 2014 or so that the CFPB had a fully functional complaint portal for each industry. So as different industries were onboarded to the complaint portal, they would issue a press release and do a large announcement and a big kick to get people aware that the complaint portal was up and running, and then essentially you see an uptick immediately when consumers start to be solicited by the CFPB, which they are doing, to onboard complaints. And one of the most common questions we get, David, about the complaint portal is, should we subscribe to the complaint portal? Now that's from companies who aren't already onboarded, and it's an interesting question, because actually the CFPB goes out and solicits companies to onboard them onto the system either in advance of that market launch or when there is a complaint that they can identify as being specific to a particular company. They'll go out and solicit the company to join the portal.
Yeah, and Jonathan, I know that there are probably a lot of questions out there too. So from a legal perspective, obviously we look at the complaints as they're submitted there, but do you have kind of a clear definition of what a complaint is?
That's a great question, and the CFPB has an extremely broad definition of what a complaint is. And so as a result of that, it's a question we get a lot too from compliance staff and from legal. And it becomes relevant in certain markets because under, for instance, the Fair Debt Collection Practices Act, Fair Credit Reporting Act, and other statutes, there's very specific conditions and requirements that start to come into play and get triggered if the consumer, for instance, disputes a debt or seeks validation. So in the situation here, though, complaint is far larger than just simply what it may be for a validation request in the debt collection context or a dispute in FCRA, in the Fair Credit Reporting context. But essentially, the CFPB would take the view that almost anything is fair game for a complaint on the company side. But keep in mind, of course, the complaint database is only the complaints that are sent to the CFPB by individual consumers. And then for those that follow sort of the universe of databases out there, there's something called Consumer Sentinel, which is maintained by the Federal Trade Commission. And Consumer Sentinel is a recipient of the CFPB complaint data for reporting purposes. So you can, on an aggregate basis, companies and consumers can get data for individual industries, essentially by different code areas, that aggregate CFPB, FTC, some state AGs, and Better Business Bureau all in one. So annually, like for instance, the Federal Trade Commission will publish a report highlighting different categories of complaints by industry. Not exactly the same as the CFPB because, of course, it's broader, but this does get rolled up into that too.
Sure, and so I guess from here we tried to look at where were some of the inflection points between a risk signal and the complaint database and a potential tangible impact to a company. So if we click forward, this is some interesting data we uncovered. Right, so this was sort of the aha moment for us, where we started doing cross sections and saying, the companies that had different levels of complaints, how many companies had actually received fines, and what did those fines break down to be? So there are a few inflection points we identified. So for companies that have less than 2,000 complaints, the probability of getting fined from the mathematics, the analysis we did here, was 7%. But still, for those companies, that 7% of companies in there that got fined, it was meaningful, right? The average fine is about $48 million. But what we did see was there was a massive tipping point when you went over 2,000 complaints. For companies that fall in the 2,000 to 10,000 complaints range, the probability of getting fined jumps up to 55%. And the average potential fine here is $125 million. And the next tipping point we saw was 10,000 complaints. When you go over 10,000 complaints, the probability of getting fined jumps up to 60%, but there is a massive bump up in the potential average fine to $758 million. And every single one of those numbers is a very meaningful impact, but obviously when you get over 2,000 complaints, there's potentially business jeopardizing size of these impacts. And a lot of what we're looking at here is what are the connective tissues? Like, A, you identify this risk signal, what are the things you can do, and then where does some of the stuff root out from?
David, like in this table of complaint ranges, how many companies are in each category? How does that work?
Sure. So that varies, right? I don't have the numbers in front of me, so I don't want to speak to them specifically. But obviously, once you get over 10,000 complaints, there's typically massive companies that have a huge amount of reach into the marketplace. So again, our report is available for download on our webpage. There'll be links here at the end of this deck. I think, as Jonathan said, this deck will be published on both our website and the Venables website afterwards. And the number of complaints we're looking at is total number of complaints in the database since inception. So if we flip forward here, there are a couple of other points here. So just to speak more specifically to that, the complaint database started in 2011. So this is 2011 through the end of 2015. So in terms of the risk signal for your company, right, if you have greater than 2,000 complaints, you should be paying a lot of attention to it because there's a large fine there. But what if you're a company that's a disruptive company in the financial services space and you haven't been around that long? What I would recommend people looking at is if they're starting to receive complaints from the complaint database, look at what your average number of complaints per month trend line looks like and see what your trajectory looks like as to when you might hit 2,000 complaints. This is publicly available information, so if you work with third-party service providers for things like collections, look at the service providers you work with to see if they're on a trajectory to get to 2,000 complaints. If they're on a trajectory to 10,000 complaints, then that's obviously a massive impact. And some of the things we go into in some of Jonathan's content here will speak to that. And a lot of it is that the liability that's onboarded by a company, of which this may be a risk signal to point you in that direction, isn't necessarily just limited to the company named.
That's right, David.
Yeah.
The service provider, and vendor management focus that the CFPB has, sort of mind your neighbor and know your vendor, it's a critical component of analyzing the complaints, as well as also deciding if there is and then taking action steps within a company on the compliance side, as well as also we see it in exams and investigations. There is a significant aggregation of data, whether it's acts and practices or just the complaints itself, that the Bureau takes. And it's not just isolated, of course, to debt collection, but in a lot of these markets, service providers can provide really core services to underlying institutions that are covered by the CFPB.
Yeah. So if we pop forward here, I think there are a few takeaways we have if we move into the second part of our content. So here are some of the key ones, and you've heard me hit on them already. And again, these slides will be available afterwards. If the CFPB has received there with 2,000 complaints on your company, obviously the probability is high, so get a handle on that and where you are. If you're over 10,000 complaints, you're not aware of it. I would assume if you're on this call and you have over 10,000 complaints in the CFPB database, someone at your company is being notified by the CFPB. So if it impacts your business, take it very seriously. One of the things that we see as a big piece of connective tissue here is that a lot of the expectations people have for the type of product, service, or offering that they're going to engage with a company on is really set by the call to action or the value proposition that they respond to at the very inception of their engagement with your brand. So potential misleading or deceptive marketing can really have a critical impact on this, and that's where this connective tissue comes full circle with the services we provide for our client companies, because having a handle on that, proactively avoiding these types of things, is a very good use of resource and time, because trying to curb a trend line after the fact because of misset expectations when you're already breaching some of these inflection points can be incredibly hard. And the CFPB does put out great guidance. And Jonathan spoke to a few of the supervisory highlights documents they put out. We even look back as far as 2013 to the responsible business conduct document that they put out there. So definitely staying in tune with what they're putting out there as they are coordinating between many different agencies is probably what we would call the absolute minimum that we would suggest to companies who ask our opinion. But in terms of the first part of the program, we wanted to review kind of this because this does speak very empirically to some of the risk signal in market.
David, a lot of folks are always looking for various solutions to deal with consumer complaints, as well as just the just general risk of enforcement or examination findings that aren't favorable. Obviously, you provide a piece of that puzzle in terms of solving it.
Sure.
What percentage does your service, help companies address?
Yeah, and it's tough because different companies have different risk profiles out there, but each of our implementations with companies is very specific to the channels they want covered and the types of traffic they're receiving, whether it's owned and operated traffic or call centers or services that they're contracting with third parties for. So I couldn't say that there is a hard and fast percentage number that I would hand out to you, but I can tell you that the scale of relativity for what people think they have exposure to versus what we tend to find in market through our technology in terms of the actual exposure they have, let's just suffice it to say that where you think you have exposure is probably an order of magnitude lower than your actual exposure.
That's very interesting, David. And one of the things that we frequently see, and oftentimes this is not readily known until essentially after the fact with hindsight, but in examinations and enforcement matters, it's typically the activities of a company that are on the edges of the core business, usually in a support function that perhaps are the softest during an exam or enforcement investigation. And so I would highlight that in terms of if folks are getting complaints about, let's say, debt collection or payment processing or other areas, and you're not a payment processor, you're not a debt collector, but an actual provider, let's say a lender, for instance, is the primary service that you're providing, and you outsource, or maybe you do internal collections and presumably have a payment function. Those are areas that I think are typically ripe for correlating, taking a drill down on the complaints, because those are the things also too, for instance, that the channel analysis is not going to necessarily address either.
Yeah, and a lot of our clients are heavily leveraging our contact center monitoring because most contact center monitoring that's in place in your contact centers now, is probably the same spot checking approach that's been in place for the last 70 years. And even though you may be in a disruptive market, how you're monitoring your contact center may be archaic. So we're working with clients where our technology is analyzing 100% of their phone calls, and we're looking for key terms. We're looking for the key identifiers in those calls at scale across your entire business, so you see true trends, not just random spot occurrences that are just data points. They're not trend lines. So that is a huge way in which, when you look at sales organizations, customer service organizations, or collections organizations, or any company that has one of those functions, you can actually get ahead of these trend lines and spot clusters of consumer issues as identified through structured data coming out of your phone calls. But let's move forward, Jonathan. I know there's a lot of other things that we wanted to touch on.
Yeah, well, you touched on a lot of compliance and enforcement trends and tips already. I think for today's purpose, to tie it all together, I'm going to highlight a couple, and certainly welcome questions, certainly about best practices and other mitigation steps folks can take, as well as also some of the stuff that perhaps you're seeing in the field. Again, please hold back on providing us questions with specific fact situations, but feel free to ask questions of a general nature through today's chat function on ReadyTalk. So, the number one trend that we're seeing, and we continue to see this today, as well as also since really the beginning of the CFPB, is a emphasis and aggressive use on the UDAP authority that the CFPB was provided under Dodd-Frank. Essentially, as promised by Director Richard Cordray of the CFPB, For folks that aren't familiar with UDAP, UDAP is the term used to refer to unfair, deceptive, and abusive acts or practices. It is very much similar to the general authority that the Federal Trade Commission has, as well as state attorneys general and others in the consumer protection space, although the second A for abusive is somewhat unique to the CFPB. The Federal Trade Commission has the power to prohibit and police abusive activity only under the telemarketing sales rule, whereas the CFPB has the ability to do it broadly against any covered person in its space under Dodd-Frank. And so the UDAP authority has been used extremely aggressively by the CFPB, and the Bureau has alleged or identified unfair, deceptive, or abusive acts and practices from the inception all the way to today in a number of places. But first and foremost, it is using it essentially as a Pac-Man to eat up and swallow anything else in its way, particularly in the enforcement context through consent orders. And so the CFPB has been leading with consent orders in virtually all markets that it has under its jurisdiction to set examples and precedent, non-binding mind you, of what it views as conduct that is either not acceptable or in the consent order context providing essentially guidance, if one wants to call it that, through enforcement. There's also specific prohibited practices cited in the CFPB's examination manual, derived in part from substantive statutes, and also regulations and previous FTC guidance. The CFPB has also been putting out guidance in its supervisory bulletins, as well as also in its supervisory highlights. And most of that comes from supervision exams. We're going to touch on one of those examples in a little bit. But we're seeing a lot of places where the Bureau is issuing guidance, and it could be, but it's not pegging that guidance to specific statutes. Rather, it's pegging it to its UDAP authority. And in different rulemakings, too, the CFPB has signaled that it would use its UDAP authority, particularly in the debt collection space, where folks are awaiting a new announcement from the CFPB, which will probably be either within the next 6 months or so, and specifically targeting collection practices of first-party and third-party creditors, and doing most of its rulemaking largely through UDAP. And small dollar lending is an announcement that's expected very soon from the CFPB. They've already put out its sort of draft architecture for what they think will be in a small dollar lending rule. And again, most of it done through UDAP, a little bit through Truth in Lending and other statutes that it has enforcement power over. Yeah. But they're really taking a broad view.
And I know that the CFPB from its inception had, at least in its first inception, had 4 major areas of focus, and small dollar lending was one of those. And I think, just to speak to that for a second, in my personal opinion, that's very much like many things in Washington, where the actual stats of the market size and the impact on the consumer wrong may not be the biggest things in the market, but sometimes it's the loudest area of complaint. So even though there have been many stats that come out that say, collections issues in the small dollar lending is not as big as some other market segments, it definitely was loud enough to get the attention for the focus of the CFPB from its outset. So like many things, once you're on the radar, you're on the radar, and even if they go and look at someone else, they probably won't stop looking at your industry just because someone else is bigger, if that makes sense.
Absolutely. And what we've also seen, too, is UDAP is for the CFPB is a gap filler, where there's either an absence of clear, express black and white law, or a desire to push the regulatory boundaries with new expectations on an industry. The CFPB has been using UDAP in a very aggressive way, and in a way that the FTC, for instance, has pioneered, but certainly hasn't even come close to using it with the same amount of impact. That's not to say, though, that the CFPB should be getting carte blanche on its use of UDAP authority, although so far there's really only one example of a litigated case involving a mortgage assistance attorney out in California where the UDAP claims of the CFPB were challenged as aggressively. Otherwise, there's been a couple lawsuits where there has been consent orders reached, including in the debt collection space. But for the most part, it's consent orders that have been driving the CFPB's UDAP sort of guidance. And again, I say that with a caveat because it's not binding guidance at all. And it's usually the result of over-aggressive claims in scenarios where companies, without admitting liability, desire to not get roped into protracted litigation. So, but there is an ability to stand up to the UDAP claims, and in particular in markets where there are statutes and practices that predate the CFPB that were viewed as compliant. There's really good arguments that the CFPB could be overstepping its bounds. So next up, and one that I know a lot of folks on the call today are engaged in, and if you're not directly involved in this within your company or on behalf of your business, I'm sure your business engages in some aspect of external marketing and advertising through third parties, lead generation activity. And the CFPB, the Federal Trade Commission, and many others are really shining a spotlight that is as intense as ever on lead generation practices of many different businesses. David, I know you and I were both panelists at the Federal Trade Commission workshop on lead generation, but there was also a pretty major announcement in December of a lawsuit being filed against the lead generator by the CFPB, and that was not the first that they've taken a look at advertising and marketing practices.
Yeah, absolutely. The level of interest from the CFPB on advertising practices is very true. When they look at lead generation, they're very interested in the funnel and the flow of information. Again, when we talk about unfair and deceptive or potentially abusive advertising practices, this definitely is an area where there's the potential for the true value proposition that someone's seeing when they engage with your company to be obscured from your view. A lot of what we do with our clients is discovering places where they're partners or people they don't even know they're working as a partner for them are advertising in ways that do not meet their corporate standards. So when it comes to lead generation, it can be an incredibly powerful channel for your business, for user acquisition and growth. But you have to have practices in place that allow you to monitor, and not just monitor in terms of spot check or audit. You have to have constantly on monitoring based on how frequently content can change on the internet that will show you where you have no exposure, confirm that you have no exposure, and not just confirm exposure on a one-off basis, but on a daily basis, and then definitely confirm when you identify exposure that you've taken remediation steps and that you have an audit trail to prove that.
Yeah, and David, in the lead generation context, what's interesting too is the CFPB is taking a look at affiliate marketing practices on the front end, and then also on the back end where the lead marketplaces are sending the leads. So the end purchaser, and that may be a lender, it may be an education institution, it could be a mortgage company, it could be any number of different service providers in the financial services sector and outside. And in the recent lawsuit that the CFPB filed, the CFPB suggested that the lead marketplace was sending leads to non-compliant purchasers and really putting the onus on the marketplace to play cop, which is something the CFPB is able to do through its substantial assistance authority, but it's a really aggressive position to be taking, particularly when the CFPB itself can't articulate what they believe to be a compliant purchaser. In some of these marketplaces, the purchaser may be organized under, say, for instance, a state licensing scheme. that varies depending on how their business is structured and how that product is used.
Yeah, and I know there were some questions about TCPA, and it always comes up. I would say as it pertains to lead generation, it's kind of chicken and egg, right? The do not call list is part of the TCPA regulations too. So I think some of the interest in all aspects of lead generation triggered some of the oversight for TCPA, and some of the oversight on TCPA triggered deeper investigation and interest in other practices in the lead generation space.
Yeah, that's right. And we're also seeing, too, in some cases, the compliance practices for TCPA, disclosures, and transparency can be very useful to mitigate some of the risks that the CFPB and the Federal Trade Commission and others have been shining a light on in recent months. And again, for folks that have been asking the question, these materials will be available on the Internet at the conclusion of this session later this week. Once they're posted, we certainly will be sending out an email with that. And for those of you who are standing by for the CLE code, we'll be providing that at the end of today's session.
Yeah. And then also, Jonathan, just on a side note there too, and there's more information that will be passed along. We are actually have a conference on June 7th in New York called Comply, which is a marketing compliance conference, a one-day conference at the Dream Hotel. Venables is participating in a sponsor there too. So if this type of content is interesting to you, there'll be information about how you connect on that and even discount codes. So I'd highly encourage folks to continue to engage with Jonathan and Venables. Definitely reach out and engage with Performline if you could use any of our services. But steer anyone who you think would be interested within your organization towards that event too. In the event it can add some additional content.
Yeah, a lot of good content out there. And another hot area for the CFPB, and again, this is an area that's relevant really for anybody in the consumer financial services space, is debt collection and debt buying. So even if you're an advertiser and marketer of products and services, there's usually a debt collection component somewhere, unless every customer is paying full price. But anytime there's a continuity program, a consumer loan, and other sort of continuity or recurring payment streams, or payment received after providing services, there's the possibility, of course, for collections and accounts receivable. And the CFPB, teaming with the FTC, has taken aim at both first-party collectors and third-party debt collection activities, as well as also debt buyers, through enforcement settlements with lenders and collectors. There's been a lot of attention given to this topic by both state attorneys general, different regulatory agencies on the state side, and then, of course, by the Bureau and the FTC. And a lot of this is going to culminate at some point later this year with an announcement of a rulemaking by the CFPB for debt collection. And they have signaled that it will apply both to first-party and third-party collection activity, which would be new and for the first time ever. Today, incidentally, the FTC issued an annual report on collection activity over on its side of the house, and expect to see a CFPB report shortly, just collecting the annual news. And a big part of that is going to be what they've all termed Operation Collection Protection, which is really a branding effort on their part to encompass all the different activities that are out there. But in terms of what's next, definitely keep your eyes on the announcement that will be forthcoming on the rulemaking, but also recent settlements that have been reached by different companies with the CFPB. Again, non-binding, but certainly good evidence of what the CFPB views as best practices in the space, involving large debt buyers and collectors and collection law firms. All offer a number of tea leaves with respect to what we'll see in that rulemaking, as well as also what we expect we'll continue to see in supervision exams, as well as also in investigations that the Bureau's holding. And what's interesting, David, about these debt collection and debt buying efforts by the CFPB and the FTC is that it ropes in also credit reporting, and it really gets into issues related to consumer contact, as well as also documentation and record keeping. We've done a lot of work in that space, doing mock exam audits gap analyses, CMS, compliance management system reviews, and it turns out that what the Bureau is able to do is get really granular. In some cases, their exams, and not exclusive to debt collection, but can last 3-4 months on the ground, whether it be at a financial institution that is primarily engaged in collection, or a bank that has a collections unit.
And when we talk about expensive, that's one of the key ones. So when you see people paying $100 million fine, that sounds expensive. But if it took you 4, 5, 6, 7 years to either do discovery or litigation on that, the $100 million fine doesn't even come close to the total cost of ownership for that entire process. So the other one of the big parts of that is, unless you have a technology in place like ours or some other way of highly curated record keeping, it's almost impossible to discover what they are asking for. And that's where you really extend your discovery costs.
Yeah, that's right. And so I mentioned this earlier, David, but data furnishings have been a hot topic too. Anybody that's using credit reports and then reporting back to the bureaus should take notice that the CFPB and the FTC, but really the outlier and leader here is the CFPB related to furnishing. We're seeing it in exams and investigations, the new enhanced e-Oscar that came out 2 years ago, and then also, interestingly enough, and we don't have this graphic here, but it's really circular. CFPB is asking credit reporting agencies, the CRAs, to provide information about furnishers and disputes and other information that then they don't use when they're doing their investigations of the furnishers.
There's also one other thing I'll point out here too, which is, especially in this day and age of disruptive financial services and disruptive business models like marketplace lending and things of that nature, and in areas of the world that you don't think even affect the credit world, there are a lot of lawsuits and active investigations being filed right now where people are receiving complaints that they're acting as a credit reporting agency when never in a million years did they think that they were doing anything that would affect someone's credit reporting. So if you are figuring out whether or not someone is creditworthy based on how many cats are on their Facebook page, but that person doesn't know that, and they don't have a way to dispute the findings of how many cats are on their Facebook page, and I'm obviously using an absurd example, but not very far off, you can't just build that into a proprietary algorithm and decide whether or not to extend them credit or a personal loan based on that, unless they have transparency on how you came to that conclusion and the ability to correct incorrect information. And Jonathan, I don't know if you're seeing this, but companies that never in a million years thought that they were going to be considered a credit reporting agency are running afoul of this more and more.
Oh, absolutely. I mean, it is a new trend too, where we're seeing, and this is actually where UDAP comes into play. The CFPB very well could be looking at organizations that are not technically consumer reporting agencies under the Fair Credit Reporting Act, but essentially holding those companies to similar standards of transparency and the ability for consumers to dispute under UDAP concepts. That is something that even the FTC has already sort of veered in that direction. It is something that's being debated also in Congress too, from a policy standpoint. But the Bureau is not always waiting for Congress to act and have black and white laws.
Yeah, they have rulemaking authority, so it's something to be conscious of, because until someone gave me some examples, I would have thought they were ludicrous to suggest such a thing.
Well, sometimes with the CFPB, something that seems ludicrous is just going to be reality tomorrow, unfortunately. Yeah. One of the things that we've seen too, and this is again another, oftentimes could be a soft spot within an organization, is payments, and specifically recurring payments, because of issues related to Regulation E under the Electronic Funds Transfers Act. And then what we've also have is scenarios too where in examinations and investigations, the CFPB spends a lot of time on looking at inbound consumer payments. And so one of the things that the CFPB has done is issued guidance in the form of a bulletin about recurring automatic debits from consumer bank accounts. And this is an interesting bulletin because it essentially says and articulates exactly what the law is, but acts as though people didn't actually know that. And I can say from experience, one of the things that was driving this particular bulletin was in CFPB exams, the examination teams would often look at the payments process and the authorizations, particularly for recurring pre-authorized electronic funds transfers by telephone, and say that they didn't think they were appropriate, that there was something that ran afoul of EFTA and Reg E, and then companies would have to raise objections to those findings. And in fact, in one instance, we had to appeal the finding and ultimately it prevailed in the appellate process at the CFPB for examination findings, which is something where there's very little transparency. And then lo and behold, about 6 months later, this bulletin comes out. And had we had this bulletin, had my client had this bulletin 2 years earlier, we would have saved a lot of time, energy, and resources. So for folks that have a payments function that's oftentimes, again, like debt collection, it's something that's universal across many different organizations, and it's something the CFPB is focusing on. David, you've touched on this earlier, vendor management. Everybody's a vendor to someone, and oftentimes large financial institutions engaged in all sorts of activities have service providers. And the CFPB is really active in this area.
Yep, absolutely, and quite frankly, whether it's where we sit in the marketing compliance side, whether it's digital advertising or anything that's happening in a call center, whether that's your internal contact center, whether it's conversations or chat, if it's a contracted call center, or even if it's a performance compensation model you have with a third party or multiple third party contact centers. No, you have to know where you have exposure, know how you're interacting with consumers, and this has probably been said ad nauseum. The ostrich defense is not a defense. So sticking your head in the sand and believing that there's such a thing as plausible deniability will get the book thrown at you based on what attorneys like Jonathan and others have shown us and what the settlements prove too. So a good defense is an active and a proactive process, policy, methodology that has the proof to show that you're doing things on an ongoing basis, not just waiting for something for a complaint to be filed against you.
That's right. I mean, we've seen situations where the CFPB has, UDAP, again, using service provider liability concepts in the payment processing world, in the advertising and marketing world, and in other service provider contexts, including even consumer financial services consultants have seen, in some cases, interest from the CFPB because, again, this concept of providing substantial assistance to a financial institution covered by the CFPB is one where the CFPB knows it can essentially find perhaps a softer target, one that was involved in providing a service but perhaps not directly subject to all of the oversight and compliance functions of its client customer. David, I know one that's near and dear to both of us because we both cut our teeth in parts in working with organizations in the higher ed space as well as marketing and advertisers in the higher ed space, is this interest by the CFPB in not only in students but basically thinking that somehow education is a financial service. What's that all about?
Sure. So a lot of this is related to how someone finances their education, right? And we're seeing the scope of this that had traditionally been focused on for-profit or career schools, scoping out a lot more to not-for-profit or traditional universities too. And a lot of this is based on the fact that the federal government has a huge footprint in this space. I think the last number I saw was $1.7 trillion worth of debt in the country is student loans, It's typically at fairly high interest rates. And a lot of this, again, goes back to what was the value proposition that the person engaged with when they saw your advertisement, engaged with your brand, and decided that they wanted to enroll in the school, and then took out a financial product in order to do so. These financial products are quite oftentimes federal student loans, and also quite oftentimes schools also offer or advise on how to get private student loans to finance the balance. And this is an area where the DOE recently has put together a new task force to even look into this, and very much looking at the connective tissue between advertising practices, enrollment rates, and then default rates on the loans, as well as outcomes. And one of the key things they're looking for was the outcome that you said in your advertisement, what actual people had in market. So if you said 98% of the people graduated and were working in their field of study, are they, or was that a false stat? And if that stat was heavily leveraged to get people to enroll and take student loans out, then that's the connective tissue they're looking for. So that's where the financial product connects to education.
Yeah, and it's also a really good case study too, because those lessons of what the CFPB and other enforcers are connecting the dots on is not really unique to education.
Yeah.
It may be remarkable though that somehow again, going to school is automatically a financial product or service that the CFPB feels it should regulate, and much like it did with telecom a couple months ago involving one of the larger mobile carriers. So at this point, folks, if you have any questions at this time for us, please send them in. If there are questions that we do not get to today, we certainly will follow up offline. But I know that we've got one question here, David. What are we all supposed to do? And that's not my question.
Yeah.
That's what somebody's asking.
What are the best practices? So what do you do, right? So I've referenced what a lot of our clients do in terms of proactive monitoring of their staff and their third-party vendors, whether it be on the sales, customer acquisition, collections, customer service side, whether it's web or in contact center. So if folks have questions about exactly how people engage with our platform and our services, definitely reach out to me. My contact information is in this deck. Email is just david@performline.com. Happy to talk through on a one-on-one what we do. Jonathan, I defer to you what some of the best practices are for handling complaints or an effective complaint protocol.
Yeah, I think with consumer complaints, there's no question, addressing the root causes and having documentation and a paper trail on that is critical. And really segmenting it not just in terms of product and service, but related to the activity. So again, if it's a collection activity, if it's a payment, if it's a customer service, if it's product specific, do that type of analysis. Oftentimes we look at that type of information when we're doing gap analyses. And more often than not, David, when somebody's asking somebody like ourselves to do a gap analysis, well, the initial inclination is look at the whole company or look at the complete compliance management system. The best bang for your buck oftentimes is to focus in on different activities. So again, like debt collection or the advertising and marketing practices or payments, that's critical because usually those are sometimes separate departments within organizations, and those are easily correctable if they're identified in advance. Of course, also there's just no substitute for looking at the full product cycle too, and that would be mapping those complaints to the product cycle is what I'd suggest. So again, if folks have any questions, please feel free to send them in. We will definitely answer any questions later today offline. And please stand by for the CLE code. And David, I know you've been mentioning a special code for Comply 2016 with a promo.
Yeah, so as we mentioned, this is sponsored in part by Venables. This is our one-day marketing conference that is great. We have speakers from different regulatory agencies who will be speaking on panels, leaders from across the marketing ecosystem as well as across multiple industries, definitely multiple sub-verticals within consumer finance. The code you saw on that page is Friends of Ven. We'll get you a 10% discount on registration. And if there's anything more you'd like to know, on this page there's a link that will take you directly to a page on the PerformLine website where you can just enter your info and download the CFPB risk signal report.